Hi, I'm Catherine Wayne Spindler. I have a law office in Milford, Michigan, and today I'm going to talk to you about one of my most frequently asked questions, which is what happens in my divorce or legal separation case or custody matter? And this is kind of the process in the court system. First, someone files a complaint, that complaint for custody, parenting time, divorce, separation, what have you, and then we need to serve the other side. Once that other side is served, they have a certain timeline under which to file an answer. Once the answer is filed, then usually cases in the state of Michigan go to a friend of the court step. In Oakland County, it's called an EIC, or Early Intervention Conference. At that hearing, what happens is you are introduced to the front of the court system, you meet your referee, you learn about support specialists, parenting time specialists, medical reimbursement specialists, and all of the things that the front of the court has to offer. And you learn about that arm of the court system that assists your judge in your case. After you get through the EIC, what starts is a period of discovery and hopefully negotiations. During that period, we gather up all of the things that we need, all the evidence, all of the documents we need to try and help our clients to get the best result that they can in their case. At that point, we can start to negotiate with the other side. Whether that side is represented by counsel or not, we start to negotiate the terms of the final agreement. If we're unable to meet those goals, then what happens is courts in Michigan generally send all cases to mediation. At mediation, there's a neutral third party, somebody who's not vested in either side, not an advocate like myself, but a neutral mediator. And that mediator goes back and forth between the two parties, talks about the pros and cons of their cases, and tries to help reach a resolution that both parties can live with. Now, I didn't say like, I said live with. And generally speaking, sometimes you don't like everything that you resolve your case with, but you're able to live with it because it makes sense. If that fails, then the final step is going to your judge and getting a judicial decision in your trial or evidentiary hearing, depending on what type of case it is. At the trial, both advocates, myself and my opposing counsel, put on our case. We put all of our clients' best information forward, and then the judge, without anything other than hearing what we have to say at that trial, makes a decision based on what they believe is in the best interest of the parties, the children, and how the case should be resolved.